This video focuses on the Second Amendment, which is another one of the obviously hotly debated, sort of very modern day relevant amendments, which is interpreted today by the courts to essentially protect the right of individuals to bear arms. Right. So the problem is that the amendment itself is very confusingly worded, and depending on how you interpret the wording, it can sort of back up either side's opinion on this does allow individuals to own a gun or it doesn't. The actual text of the amendment is a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Some people look at it as it just protecting the right of a militia to bear arms. Others look at it as the right of individuals, people, to bear arms. And this video sort of takes an interesting take on just how the placement of the commas actually determine, like, perhaps your sort of like stance on the interpretation of the amendment.
A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is the complete unabridged text of the Second Amendment. As much as it's brought up in the ongoing and heated gun control debate, it seems like it would be more than 27 words. But it's not. And therein lies the problem. In a lot of ways, the fight over the Second Amendment has become a fight over interpretations, semantics, and even punctuation. Some people claim that the Second Amendment applies only to state militias, which, for the record, don't really exist today in the way they did in the 18th century. Others argue that it gives rights to both militias and individuals. Historically, the Supreme Court has sided more with the only militias side of the argument. But in 2008, they changed their tune, thanks partly to one single comma, this one. It all stemmed from the 1975 Firearms Control Regulations Act, which banned Washington, D.C. residents from owning most guns. Gun advocates continually challenged that law, and the debate worked its way up to the courts. In the end, the Supreme Court agreed that it violated the Second Amendment, and it all came back to that comma. Justice Scalia, who delivered the opinion of the court, agreed with others before him that the second comma divides the sentence into two unique thoughts. First, that a well-regulated militia is necessary to the free state, and second, that the rights of the people to keep and bear arms should not be infringed. He went on to say that Part 1 informs Part 2, that we need gun rights because militias are necessary. Scalia did recognize the amendment's unique grammatical structure, and he offered his own rewrite to try and clear things up. Because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This became the official legal interpretation of the Second Amendment. But that doesn't mean it's universally accepted. Many people still believe that the amendment refers only to state militias. They argue that the crux of the sentence is, a well-regulated militia shall not be infringed, and that arms are the right of an organized citizen military group, not the people. So what about that comma? Well, many grammar experts and historians say that's just how people wrote back then. They put commas everywhere. The 18th century was essentially the Wild West of punctuation. And in fact, many scholars say that this third comma, it's completely pointless and misplaced. It's a well-known fact that, as smart as the Founding Fathers were, the Constitution is full of grammatical errors. But the debate is about even more than that. Both sides have debated the definition of the terms bear, arms, and well-regulated. The capitalization of words even differ from copy to copy of the Constitution. In the end, it's clear that the US Constitution is an important piece of world history, but that doesn't mean it's a perfect document. And this is maybe why the country is so divided on the gun issue. It all goes back to a grammatically incorrect run-on sentence written by men who cannot be called upon to clarify what they meant to say. Because where America stands now, there are two diametrically opposed groups of experts. On each side, there are linguists, historians, lawyers, scholars, very smart people. They're both looking at the same 27 words, and they're both seeing two completely different things. In short, some see the rabbit, while others see the duck.
All right. So you get a little background on sort of the difficulty we have in sort of interpreting what the actual meaning was. The bottom line today is that you saw that they referenced the 2008 sort of Washington D.C. situation, in which this really kind of changed the philosophy. Interesting background if you're a sports fan. Washington D.C. had the highest murder rate going for decades of any U.S. city. And their NBA franchise used to be called the Bullets. The NBA sort of persuaded the Washington franchise to change the name to something a little bit less sort of like unfortunate. Like maybe it was a bad look that the city with the highest murder rate in the United States had a basketball franchise called the Bullets. So they changed to the Wizards. A little backstory. But because of this high murder rate, DC essentially outlawed handguns in 2000, in the like mid 2000s, and basically like sued an individual. And this was really the first time the Supreme Court ruled that individuals have a right to own guns and struck down DC's law. Now, this case you don't need to know, but one of them that you do need to know, right, is McDonald v. Chicago, which was 2 years later. You may say, like, well, like, why is there another case that's essentially dealing with the same issue? Like, so Chicago's really strict gun control measures, which almost amounted to an outlaw of handguns. And that's because the DC decision was unique in that it couldn't just be automatically incorporated into the state because DC is not part of the state. So they had to hear an actual case involving a city in a full blown legitimate state, which was this. Again, McDonald v. Chicago in 2010. We'll talk about this case in a bit more detail.